Thank you for attending today. This is the third in a series, Protecting Your Business with Employee Restrictive Covenant Agreements. And Mary Claire Smith is the MMM attorney who will be giving the presentation. John Yates has decided to join us. He's free today at lunch, and so he'll be making a few comments and answering maybe any chat questions you have. John has worked a lot with, of course, with Mary Claire and is the partner in charge of our corporate technology group. I'm Ann McDonald, Director of Business Development. Next slide. Of course, we have Zoom etiquette we need to cover quickly. Please mute during the presentation. Address your questions in the chat box. Set your view to speaker view. And we are recording this for educational purposes. This is not specific legal, accounting, or tax advice. Consult your advisor, and we'll make this presentation and the recording available after this for you to take a look at and share with others. And this is, as I said, the third in a series. Please stay tuned for the next one. Put it on your calendar, April 6th at 10 o'clock. It's a special fireside chat with one of our clients and also an ATV villager, a Sure Sign. So we'll have a special conversation with Courtney Schickel, who is the Chief Revenue Officer at a Sure Sign. And this will put all of this into focus, all of the information from the three different sessions on how you use contracts and the need to use contracts in the most important ways within your company, why it's so critical. So let's see, let me introduce with a little more information Mary Claire. Mary Claire counsels employers with respect to hiring and separation concerns, restrictive covenants, internal investigations, policy and procedure reviews, and compliance with federal, state, and local employment laws. She went to Samford University to get her law degree, an undergraduate at the University of Mississippi. It is my honor to present Mary Claire.
Thank you so much, Ann, and thank you everybody for attending. Again, we're here today to talk about restrictive covenants. I know a lot of you are entrepreneurs of tech companies, so I thought it would be most helpful today to talk about how restrictive covenants can help protect your business, and then go through some of the practical pointers and do's and don'ts of what you should do in having them. So what are restrictive covenants? I'm sure most of you all know this, but simply put, they are agreements by employees to refrain from engaging, or actually to engage in certain activities during employment and for a period of time after employment. And they are, of course, valuable tools that can protect your company's business and competitive information. I thought it would be helpful to start with a little hypothetical for you guys of what can happen if you don't have restrictive covenants. So say your company is developing a new app and you hire John Doe to spearhead the app, and then several developers that are going to work underneath him. And John is going to be the face of the app. He's going to be the guy communicating with all of your customers, and is going to be the guy promoting it. So after about a year or so of working for your company, John comes to you and says he's leaving for a better opportunity. He leaves, and in the following weeks, all the developers that worked for John decide to leave with him. And then in the coming weeks, you come to find that some of your customers have left you too. So you come to us and say, obviously you're angry. What can we do? We got to stop John. We got to stop all of these employees. They've taken our information and they're working for a competitor. And I say to you, okay, well, send me their employment agreement. Send me any restrictive covenants they have. And you say they don't have any. And unfortunately, without these restrictive covenants, you're left without any recourse to stop them. So again, that's just a worst case scenario, and an example of how restrictive covenants can help protect you. So if you're going to have them, some key issues to consider that we'll go over today are what exactly are you trying to protect? Is it just your information? Is it your relationships? And once you determine that, then we're going to determine what kind of restrictive covenants you might want to have. Another key issue to consider is where do your employees actually work? So enforceability of restrictive covenants varies by state. Many states have their own statutes and laws that govern whether and how they're enforceable. What is required to actually support a restrictive covenants agreement? They have to have some sort of consideration for the employee to sign them. And then another thing to consider is when you're actually hiring employees, are they bound by restrictive covenants with their former employer?
Clay, let me ask you a question on that last point, if you could go back to it, which is the idea of going, when you're hiring people, is looking at the agreements with former employers. Just for the benefit of the audience here, how much of an inquiry should a company engage in there when you're getting ready to, back to your hypothetical, let's say somebody's getting ready to hire John Doe. Let's say my company's getting ready to hire John Doe. Do I have an obligation to ask John Doe if he has restrictive covenants, or should I just be quiet and like cover my ears and eyes and hope that, hope I don't, there's no problem there? What do you think?
That's a good question, John. It is something, and especially in this business, that you might want to consider asking. And another way you could protect yourself is by having these employment agreements. Have a provision in the employee's agreement, if you hire him, that says the employee promises he's not bound by any other sort of covenant with a former employer or third party.
Good point. So adding that clause would be a good practical pointer if I'm hiring John Doe, is to put that clause in there so he, hopefully he reads the agreement and tells me he didn't have any other agreements. Thank you.
Exactly. Okay, here's some examples of the types of restrictive covenants that you're commonly going to see. So you have your confidentiality, non-disclosure provisions. These are promises by the employee that they're not going to use your information or trade secrets. Non-competition, this is the one you're going to see a lot and that most employers have questions about. This is a promise not to engage in competitive business. A customer non-solicit, it's a promise not to solicit your company's customers and or prospective customers. Employee non-solicits, this is a way to protect employees from soliciting your other employees and potentially independent contractors and other relationships you have. And then lastly, we'll talk a little bit about non-disparagement provisions. This is essentially a promise that the employee is not going to talk bad about your company or any of your employees when they leave employment. Okay, so we talked about all the ways restrictive covenants can be a good thing, and obviously they can protect your company. But there are, of course, going to be some drawbacks. So one of the main things is they can deter potential employees. So you're looking to hire somebody and you present them with this employment agreement with this long drawn out non-compete. They may not be willing to sign it, and in turn, they may not want to work for the company. You have to ask yourself, is this something you'd be willing to sign? Another thing to consider is maybe limiting the covenants. If you're going to have restrictive covenants, exclude certain covenants that you might not need. Maybe you don't care so much about the employee working for a competitor as long as they're not taking your customers. Maybe you only care about certain employees having confidentiality provisions so they don't actually use your information.
So Mary Claire, let me ask you a question there. Let's just say that you go back to your John Doe example. Let's say that I'm getting ready to hire John Doe, and I'm also going to hire Ian Fisher, hypothetically. And Ian already works with me, and I'm getting ready to hand employment agreements, and they include this a restrictive covenant. And but John Doe says, look, I'm not signing this thing with this restrictive covenant. And so can I go ahead and scratch that restrictive covenant from John Doe's agreement, but leave it in Ian Fisher's agreement? In other words, do I have to be uniform as far as across the board that everybody has that covenant, or can I be choosy if I have to be choosy in order to get the John Does of the world to come to work for me?
Yes, sure. You can certainly do that. If you really want John Doe and you need him there and he's not willing to sign the non-compete, and that's something you consider, you'd rather have him there than have the non-compete with him, you can certainly exclude it from his agreement. It's negotiable.
And poor Ian's still under your non-disclosure or non-compete agreement, Ian. Sorry about that. But you'll probably negotiate a better deal in your next round of employment agreements. Thanks, Mary Claire.
Sure. Okay, let's talk about non-competes first. This is, again, the one that everyone's usually has questions about. They are generally the most onerous to be enforceable. I'll just use Georgia as an example. So in Georgia, non-competes are only enforceable to protect the company's legitimate business interests, and they have to be limited in time, geographic area, and scope of the prohibited activity. So that's Georgia. And then you have other states that won't enforce non-competes at all, like California and a few others. Okay, so what is reasonable? And again, I'm going to use Georgia as an example, but keep in mind that it depends on state law. So every state, most states have statutes that govern non-competes, but every state differs. So in Georgia, the duration of the non-compete is usually presumed to be reasonable if it's limited to 2 years or less after separation of employment. In Georgia, you have to have a geographic restriction. So what's reasonable is usually anywhere where the employer conducts business is generally reasonable, provided that the total distance is reasonable. But sometimes nationwide or worldwide territories can be viewed as overbroad. And that can be tricky for businesses like tech companies because you guys are servicing companies nationwide. A lot of employees are remote. Everything you do is spread out across the country. So a way you can address that is by maybe including an additional provision that limits the non-compete to anywhere where the employee worked. And again, maybe the employee works nationwide. As long as you can show proof that you know where the employees worked and the kind of customers that the employee is supporting, it's generally going to be enforceable. Another way you can tighten it up a little bit is maybe to limit it to a specific customer list, a list of prohibited customers or prohibited companies that you don't want that employee working for. Lastly, scope of activity. In Georgia, you want to limit the non-compete to the same or similar activities that the employee was actually performing on behalf of your company. We referenced the janitor rule. So maybe you can't have a non-compete that prohibits your employee from working as a janitor for another company if he was, say, an executive for you.
So Mary Claire, let me ask you a question. I see that one of our participants, Ernie, is in his car driving. So he's mobile, right? So he may wonder now what state law applies. So Ernie's driving. I'm hypothetically believing Ernie's driving into Alabama right now. And so he may be working in his Alabama office, but he lives in Georgia, right across the state line. So Ernie's asking himself, if these restrictive covenants and non-competes depend on state law, what state law is going to govern Ernie's non-competition covenant? He lives in Georgia, but he works over there in Alabama. What do you think?
Sure. So if Ernie actually lives in Georgia, you're going to want to go with the state where Ernie lives. So that's going to be the governing law. But in terms of restricting his activity, in terms of a non-compete, if he conducts business in Alabama, and you know that, if he conducts business in, let's say, South Carolina, then you can limit his non-compete in those specific territories where he's conducting business, even though he lives in Georgia.
Great. Thank you.
Sure.
Keep driving, Ernie. Keep your eyes on the road.
Okay. Kind of a long slide, but another thing to consider for non-competes is who do they apply to? So in many states, they're only enforceable to certain employees. In Georgia has this long drawn out definition of who non-competes can apply to. And in short, it's employees that are going to be interacting with your customers, that are going to be having marketing responsibilities, managing the enterprise. They have a definition of a key employee that further defines that, or a professional. Other states will say they're only enforceable to, or they're not enforceable to lower salary employees or lower level employees. So just something to consider here is, who do you want to sign these non-competes? Is it going to be some lower level employee that has minimal access to your confidential information? Is it somebody that doesn't really interact with your customers? If so, then it's probably not necessary for them to have a non-compete. Okay, so here are the practice pointers for non-competes. Again, try to think about limiting them, limit them to the extent practicable, only require certain employees to sign them, consider where those employees provide services, and limit the restricted territory to that area. So again, we're having this issue come up with remote work. You've got an employee who lives in Georgia like Ernie, but he's basically servicing customers everywhere. You can have a non-compete that restricts him from performing services where he works, but you got to consider where he actually works, and you need to be able to support that he's servicing customers in those other territories. And then again, consider those employees' duties and limit the scope of that prohibited activities based on what they actually perform for your company.
You mentioned earlier, Mary Claire, about California. So let's just make the hypothetical and assume that Ernie is driving across the country. So he's getting ready, he's decided he's going to go to work in California. And he's coming to work for me, and somebody in my office just sent him the standard Georgia non-competition covenant that has all the Georgia language in it. But now Ernie's going to be a California resident. What should I do? And a lot of the folks I think that are listening today probably have one or more employees in California. Should they just strip that clause out completely? Should they leave it in, or does it make any difference, do you think?
Yeah, so if you have an employee in California, like we said earlier, California is not going to enforce a non-compete. So if the time comes around where Ernie's violating his Georgia non-compete and he's competing, but he's in California, he might say, well, I live in California, so my agreement it's still governed by Georgia law. California is not going to enforce a Georgia choice of law provision if it conflicts with their state. So if Georgia has a non-compete that's prohibiting this employee from competing in California, they're not going to enforce that. So it might be worth considering having a new employment if Ernie is now a new employment agreement if Ernie is now working and living in California.
So let's assume we got the new agreement. Tell me about these customer non-solicitation covenants, if that might work in California, and how does that work in Georgia? So you got a slide up and walk us through that.
Okay, yeah. So customer non-solicits. In California, they are further limited. You can have them in California, but they need to be limited to the extent they prevent the employee from using the employer's trade secrets to solicit customers. Not a similar limitation in Georgia. In Georgia, they just have to be reasonable in duration, that 2-year period, and scope. So for scope in Georgia, there doesn't have to be a geographic restriction to be enforceable, but it needs to be limited to customers and prospective customers with whom that employee had material contact. Georgia actually defines what material contact is. A lot of other states have similar rules or statutes where the employee actually needs to have some sort of relationship to that customer in order for you to prohibit them from soliciting them. Does that answer your question, John?
Yeah, I think the key on this, I guess, is that you got to have this clause that probably, let's just say Ernie's going back and forth between Georgia and California, and want to make sure that, I guess you've got to look at both states' laws to make sure that you're following whichever one is most narrow in this situation too.
Exactly.
Does that suggest that maybe everybody that is working in the tech area needs to continually be monitoring where their employees reside, and maybe at least periodically finding out when they change residence? I mean, people like Ernie may be mobile. Talked to a client the other day. He literally took his entire company, made it virtual, and now he's living in a mobile home and driving all over the country. So I guess, does it suggest that tech companies that have this mobile workforce, they need to constantly be on the lookout to find out when people are changing residences?
Yeah, definitely. I think so. And, we're still trying to figure out what the inquiry is there. Is it, he's in a mobile home. Where does he get his mail? Where does he claim his residence? And that's something you can follow up with your employees on. Okay, employee non-solicitation covenants. Again, enforceability is going to depend on state law, but generally these are enforceable in most states to the extent they are going to prevent your employees from soliciting or inducing your other employees or contractors to work for a competing business, or otherwise just interfering with their employment relationship with these employees, causing them to terminate their employment relationship. Some states also allow no hire provisions, so you can have language in the agreement that prevents the employee from hiring without actually soliciting one of your employees. In other states, which are a little more strict, the employee might have to have some sort of contact, whether it was a supervisory relationship, in order to be prohibited from soliciting those employees.
Let me ask this question, Mary Claire, on this non-solicitation covenants. I'm wondering, let's just say back to your John Doe example. John Doe leaves his company. He has a lot of friends back there. He now sends out on LinkedIn an announcement that he's changed. He's gone to work for John Yates Incorporated, and it's a fantastic place to work, and you really need to come. But he knows that all those people that were formerly at his company are connected to him. And so, what he's hoping is, of course, they all, contact him. He also puts on there, I'm really excited about working with, Yates Technology Company, and we're hiring. We got a lot of openings over here, so come on over and, join this great company. Do you think that's a problem? I mean, is it a situation where the John Doe who's just left his company should probably be a little quiet about it, assuming that he had a non-solicitation covenant in his agreement? Or is it okay to go ahead and tell the world that and then also say, hey, we're hiring, come on over?
Yeah, that's a good question, John. I think it's all going to be fact-based, and it's going to depend on how the court looks at it. Different courts are going to address it throughout the country differently. But I think where that employee, John, might have crossed the line is when he says we're hiring. It's okay, say he didn't even have a non-compete and he went to work for a competitor and he announced that on LinkedIn. That's probably fine. But if he has an employee non-solicit and he's advertising that they're hiring and he has relationships with some of these employees on LinkedIn, that might be considered crossing the line.
So that might suggest also that when you hire, if Yates Technology Company hires John Doe, that in addition to finding out whether John Doe had a non-solicitation covenant, it may be worthwhile saying to John, listen, be careful about what you post on social media. We don't want to get you in trouble. And frankly, we don't want to get us in trouble. So a little bit of a counseling up front might be valuable.
Exactly.
Good points.
Okay, confidentiality, non-disclosure covenants. These are what you're going to see the most of, and these are generally the safest covenants that you can have, that you want to have to protect your information, especially for tech companies. You're going to have trade secrets. This is basically, we'll get to the definition of trade secrets, but you want some sort of language in an agreement that is going to define the information you're trying to protect. You want language preventing the employee from not just disclosing that information, but from using it or accessing it to their benefit or for any other purpose other than for the employment relationship. And again, you can have contractors too sign these types of covenants. This is something we see a lot of in independent contractor agreements. It's important to include a confidentiality, non-disclosure provision, especially if you have someone working for you for a short time, they're going to have access to this information, and you want to make sure that they keep it safe and they're only using it for the purpose of their relationship with you. And a big thing here, you also want to make sure you require the employee to return any company information or confidential information that they might have in their possession upon separation. So whether that's asking them to return their laptop, any copies of things they've saved, anything on their email, on their phone, all that stuff needs to be returned. And then the duration of enforceability of these, it's going to be in most cases, as long as the information you're trying to protect remains confidential or a trade secret under applicable law.
Mary Claire, let me ask you, you put down here that, require the employee to return company information upon separation. Well, a lot of that information potentially could be in the cloud somewhere. And I'm wondering to what extent it's the employee's obligation to go and search around for that, or whether the employer can, or whether there's how that's done in the current environment, because it's a little different from the past where, you might have had a written business plan that you could get a copy of it back. How do you recommend companies, make sure that their employees have returned everything? Are there some practical pointers there?
Yeah, that's a good question, John. So one thing you can do is make sure you have the employee do like a full sweep of their computer, turn anything that they have back over, whether it's on an email, you're gonna end the access to their email. So you can actually search their email too. And a lot of the times you see this arise when there's actually, maybe the employees returned everything to you physically and any hard copies, but there's still a concern that they might have something, in which case you can have somebody do a review internally. Maybe it's your IT team, a review internally of their computer or email to see if they still have that information. So it's kind of a back end.
So I'm going to ask a tricky question here, for which I think the answers have been all over the board. But let's just say back to our John Doe example. So John Doe, when he was working with his former company, also just went LinkedIn crazy, went out and connected with everybody and their grandmother and grandfather in order to have connections. And now John Doe is left. All right, he's given everything back because you've told him he has to, as he leaves the company. But he still has his 50,000 plus LinkedIn connections with all of these customers and all this other information, relative to connections and the like. And John Doe's feeling on it is, hey, look, I created all this stuff. I did it like in the middle of the night, and I should be able to keep my LinkedIn page. I think the cases have been all over the board, but any thoughts about that? Because people are building LinkedIn, and that's sort of their database now. Is it, can John Doe claim he owns it, or does the company have some claim of ownership, do you think?
That's tricky with LinkedIn, but with a lot of things that employees claim they own because they created, you can also have in your agreement an IP assignment provision, something that says anything you created while you worked for the company now belongs to the company. And that's the best way to protect yourself there.
That's a great question too. And it's maybe one that we can answer in a future session, which is, do you include something like your LinkedIn profile that, or we co-own the LinkedIn profile, or you have to delete all references to any customers on, that are associated with the LinkedIn profile. You could see how it could get pretty tricky pretty quickly, but those are all good points. And I think you raise a good point here too, to maybe include it in the agreement to make sure that it's an issue that can be addressed. Thanks.
Sure. Okay, these are just examples of what is confidential information. Again, when you have a confidentiality or non-disclosure agreement, you want to be as specific as possible. Give examples of what you're trying to protect. If it's helpful if the state that is the governing law, usually it will have a statute defining confidential information like Georgia does. So we try to include language that here at the bottom that actually defines confidential information. Trade secrets, methods of operation, names of customers, price lists, financial information. Try to model your definition after the statute so that it's as enforceable as possible. Okay, same thing with trade secrets. The Defend Trade Secrets Act of 2016 actually defines what a trade secret is. And short definition is it's something that derives independent economic value from not being generally known or accessible by your competitors. And second, it needs to be subject to reasonable efforts to maintain its secrecy. So that's a big thing. I had a case recently where a client had several, what I would consider trade secrets. Here are some examples down here below: customer list, pricing information, software, unpatented inventions. They had all this stuff that was taken from 2 former employees. But when we went to court, we found that they weren't password protected and pretty much anybody could access them on the system. So the court found that they weren't trade secrets because they weren't subject to reasonable efforts to maintain secrecy.
So let me ask you this question. Let's assume a situation back in our hypothetical. We got John Doe there, and Yates Technologies hires John Doe. All right, we asked John Doe, hey, John, do you have an employment agreement or any kind of restrictive covenant with your former company? And Doe says, no, don't have anything. And we say, fantastic, give us all the trade secrets you got, because there's a new agreement you have in place, and tell us what kind of product plans are they engaged in, and what give us some other information. What else do you have? Do you need to have an agreement in place in order to protect trade secrets, or is that a situation where the former employer can protect their trade secrets even if John Doe never signed an agreement with regard to protecting trade secrets?
Yeah, so technically, John, under the Defend Trade Secrets Act, trade secrets are protected by law. So even if you don't have an agreement, this is something that you can still likely go after the employee for, but still we always recommend including it and spelling it out in the agreement to the extent that you can.
So in that situation, poor John Doe, can't give up those trade secrets. If he does, he's going to potentially expose himself to liability and I guess his new employer too. So
Exactly. Yes.
good points.
Yeah.
One other question there. A lot of times people put trade secret on everything, right? You send out a PowerPoint, a beautiful PowerPoint like the one you've done here, Mary Clay, you throw trade secret on it. What's your advice with regard to what you marked as trade secret or confidential information? Because I know a lot of folks listening to this are probably thinking, well, I want to make sure I've protected my trade secrets, but I'm not exactly sure what it is. So maybe I should stick it on just about everything. What do you think?
Yeah, kind of like I was saying earlier, just because you call it a trade secret doesn't mean it is. It's got to meet these specific narrow definition. It's almost like a heightened piece of confidential information. If it's not subject to reasonable efforts to maintain secrecy, if it's not password protected, if you don't limit access to it, if it's not something that would harm you if your competitors got a hold of it, it's not going to be a trade secret.
So I guess some level of caution about sticking trade secret on everything, because you might potentially dilute down what really is a trade secret and create some real issues. Is that the case?
Exactly. Because you can still have information that's considered confidential information that's not a trade secret, and you can protect that information with the non-disclosure provision.
Good advice. Thank you.
Okay, non-disparagement covenants. These, you don't really think about these when you think of restrictive covenants, but they're good to have because they're going to prevent your employees from talking bad or saying negative things about the company or your officers upon separation. And these are great when you have disgruntled employees and you end on bad terms and you don't want them saying bad things about you, obviously. So it's good to include these in any employee covenants agreement. Sometimes if you present an employee at a covenants agreement with a non-disparagement provision, they might try to negotiate it with you and say, hey, let's make this mutual. I don't want you guys talking bad about me when I leave. That's okay, but we generally try to discourage those because as you know, it can be hard to have your whole company all of a sudden not say anything about this employee. So we try to limit those to senior leadership if we're going to have a mutual non-disparagement provision.
Okay, I'm going to ask you a question, Mary Claire. So I have a Facebook account, but I never look at it, but my wife does. So let's be hypothetical here. Let's say that I'm John Doe and I've just left the company and my wife is really very happy with that because she didn't like the former company. And so unbeknownst to me, my wife is on Facebook on my account, by the way, which has my picture on it, writing stuff like, thank goodness, John has left his former company. They were a bunch of deadbeats and I'm really glad that, he's no longer there. Now I didn't do it, but it's on my wife. And most people know, by the way, that my wife controls my Facebook account. Do I have a problem? I mean, do I need to be in a position where I've got to be looking at social media and be careful about what I say and possibly triggering these non-disparagement covenants? And I need to make sure my spouse or friends are not promoting some kind of negativity toward the former employer.
Definitely, John. And that's something we would recommend in these non-disparagement provisions is limiting any communications of social media. And we'll put the term social media in the actual provision. And you can say it's directly or indirectly. So anyone on your behalf talking badly about the company or its employees. And again, it's your Facebook page. So whether it's your wife or your brother or someone else, it's coming through you and it's being displayed to the public through you.
This is really a key point, I think, that, in the olden days where it's just a case of, maybe somebody just, your spouse talks to the neighbor or something, that's one thing. But if you got, 10,000 connections on Facebook and all of a sudden, your spouse splashes up the fact that, sure, I'm glad that John has left that deadbeat company. They're a bunch of worthless morons, that could be a real problem. So I guess your point on this is that you got to be careful if you're the departing employee and you got a non-disparagement covenant. You may need to talk to some people around you and say, look, just keep your mouth shut and keep your fingers off the keyboard. And by the way, maybe I'll change my password to my Facebook account so my spouse can't get in there and say anything on it.
Right, exactly. That's a good point. Okay, this is a key issue we should talk about, the choice of law. So I've gone back and forth saying that the non-competes non-solicits, they're all governed. They depend, the enforceability depends on the state law. So as the employer, if you're drafting a restrictive covenant or you're having an attorney draft a restrictive covenant agreement for you, you're going to include a choice of law provision designating what law controls the agreement. Most courts will enforce a choice of law provision unless the chosen state doesn't have a substantial relationship to the parties or the transaction, or if the application of the law of the chosen state would be contrary to the fundamental policy of the state which has the greater interest. So going back to the California example, if your company is in Georgia and you want Georgia to be the governing law, but you have the employee that is signing this agreement living in California, that's going to be a conflict of the choice of law. So you're not going to want to have a California employees agreement governed by Georgia law, because especially if you have a non-compete, they're not going to enforce that in California. So practice pointer here, big takeaway, is that the governing law should generally be in the state where the employee is located. And then I know we talked about remote employees. So even if the employee is working remotely, they're servicing customers everywhere. You want the governing law to be where they're located, where they're working remotely.
So Mary, let me ask you this question. A lot of folks that are probably listening to this also have offshore development or development, personnel or contractors in Eastern Europe or in Latin America or someplace else. And they're, it may even be the John Doe that lived in Atlanta, but now, he's moved to Costa Rica because he likes the weather there better. Do you need to worry about the international laws as well? Because John Doe in Costa Rica can still be out there soliciting employees, can still be out there competing and other things. And how do you deal with the international piece of things? Do you have to contact, work through you and then you contact an attorney there to make sure that these covenants are enforceable?
Yes, yeah, definitely, John. And you see this issue a lot too. So when you have somebody that's all of a sudden working offshore or internationally, we'd usually recommend that you contact us, and we usually have a relationship with somebody that can advise on that territory specific law and whether their restrictive covenant is going to be enforceable there.
Yeah, that's going to become much more important as a lot more offshore development happens. Thanks for that. That's good advice.
Sure. Okay, another key issue is what's being offered to support the agreement. So we call this consideration. Every restrictive covenant agreement requires some type of consideration in order to enforce the promise by the employee. What is sufficient consideration varies, again, depending on the governing state law. In most states, the employment itself is going to be the consideration. So we agree to employ you, John Doe, if you sign these restrictive covenants. Sometimes, however, you might want current employees to sign restrictive covenant agreements, or you need to make revisions. You might want to add a non-compete where there previously wasn't one. Some states recognize continued employment as sufficient consideration to support that agreement. Others don't. So in those states that don't recognize continued employment, some type of new consideration is required in order for it to be enforceable. And that's usually in the form of a raise or a bonus or a promotion, or simply access to new confidential information. Okay, so wrapping up some of the key takeaways here. Again, consider what you're trying to protect. Do you actually need the restrictive covenant that you're trying to include? For which employees? Try to limit it to the extent you can so that it's enforceable. Another big thing is make sure the specific restrictive covenants you want that you decide to have are going to be enforceable in the state where the employee is located. If not, limit to those restrictive covenants that are enforceable. So in California, let's take out the non-compete. Maybe you can have a non-solicit that's limited based on California law and an employee non-solicit. If the covenants you want are enforceable in the state that's governing the law, are they reasonable? Are they sufficient to protect your interests? And then if a current employee is signing, or current employees, determine whether the governing law requires new consideration to enforce that agreement. And then lastly, like we discussed, be careful about new hires. It's always smart to inquire whether they're bound by any pre-existing restrictive covenants with a former employer. And then if you're going to have them sign a restrictive covenant agreement, include language that says that they don't have any promises to or aren't bounded by any existing obligations to third parties.
Mary Claire, great key takeaways. A couple of questions that have come up here. One relates to employee handbooks. What are your thoughts about employee handbooks, and are they being used now in the tech environment? Are they online, and how do you keep them updated?
Yeah, employee handbooks are great to have. What they are is they're going to include your policies, general policies about work hours, anti-harassment, anti-discrimination policies, reporting procedures. But the key thing with handbooks is they are not contracts. So you're not going to see restrictive covenants in an employee handbook. It's still something you should have, and it's always something we can help you with. But if you have a specific agreement or promise that you're trying to enforce for an employee, that should be in a separate agreement rather than in the employee handbook.
Good point. Another question that's come up relates to the fact that as employees, and you talked about employees changing their location and residences, and we used our example of Ernie driving all over the country and having different residences. Does it make sense for companies to do a periodic audit of their, and I put audit in quotes, of their employee base to see where they're located? I mean, is that something that, and if it turns out that Ernie's moved from one jurisdiction to another, moved from Georgia to Minnesota, to then go to Ernie and say, Ernie, you just moved to Minnesota. We'd like for you to sign the Minnesota agreement. I mean, is that what you should do? And should you do it quarterly, or how often do you think you should do it?
Sure, yeah, it's always a good idea to stay on top of things like that. And I would say maybe quarterly, maybe once a year, just check in with your employees, make sure, hey, we want to make sure your address is still the same. Another thing you can do is actually put in your handbook that employees are obligated to notify human resources of any change in address. So that way, and give them a procedure to do so. So that way you can stay on top of it.
And a final question related to employees and independent contractors. And there's some questions I think people have asked about, if I have an employee, but I'm not sure whether they're independent contractor or not, but I'm, sort of treating them like an independent contractor. And I want them to sign an agreement, and the agreement, I wasn't quite sure whether I should put it, restrictive covenant in an independent contractor agreement. How do these covenants work with a true independent contractor, somebody that, is not an employee, but should you include these covenants there as well? And are they generally enforceable with independent contractors?
Yes, you can have all the same covenants for an independent contractor. It can be a little trickier with a non-compete, because if someone is truly an independent contractor, they are allowed to, and you should have language allowing them to work for other companies and not just have them work exclusively for you. But you can still include language preventing them from actually working for a competitive business or using your information for a competitive purpose while they're performing services for you. But certainly, if you have an independent contractor agreement, you should always include those confidentiality, non-disclosure provisions to protect your information.
So I'd say there's one other question that's come up, and that relates to, you talked earlier about non-competes and about the fact that, how to draft them. A lot of these tech companies apparently have situations where, they have like 4 competitors, and those are the competitors they don't want John Doe working for. Anybody else they don't really care about, but these 4 competitors are pretty important. So they want to list those 4 competitors in the agreement and say, you will not compete by going to work for one of these 4 competitors within a period of time. Is that okay? And how do you address the situation if some of those 4 competitors, let's say, get gobbled up by somebody else? In other words, maybe they're not, those competitors, change their corporate structure at some point because somebody else acquires them. Should companies think about listing 4 competitors? Is that a smart thing to do?
Yeah, that's definitely a business decision. It is a good idea if you can in some states to limit the non-compete to a specific list of competitors, but that's a good point you raise. And maybe a way to address that is you want to include language that prevents the employee from working for those 4 competitors or any parent or affiliate of those competitors. And it may not be a good idea to have that if you think, if this is a business that's growing and there's likely going to be more competitors in that arena other than those 4. There might be a 5th or 6th competitor that's developed in the next year or 2, and that's where your employee goes. And you didn't think about that when you drafted the agreement.
Mary Claire, you've raised some great points and great practical pointers. I think if we go to the next slide, We'll see again the reference to our next event, which is April 6th, a fireside chat with ATV Villager AssureSign, which is a very fast-moving company there, and Courtney Schickel, the Chief Revenue Officer. Mary Claire, I believe your slides will be available also, this PowerPoint, to the attendees, and we'll be sending them out to the folks that have RSVP. Is that correct?
That's correct. Yep.
Great. And where can people reach you, Mary Claire, if they have questions about any of this information?
You are welcome to email me. My email is msmith@mmmlaw.com.
Mary Claire, thank you very much. We appreciate also the Atlanta Tech Village for hosting this event. It's been great practical information, very important in this current environment. And as Mary Claire has pointed out, lots of changes as a result of the mobility and virtual nature of companies now. So stay tuned for a lot of case law in this area. Mary Claire, we appreciate what you're doing and the counsel you've provided to tech companies. Many thanks, and look for this recording and also for the PowerPoint coming to you soon. Have a great day.
Thanks, everybody.